This program is brought to you by Emory University.
I just want to formally welcome you all to Emory Law School on behalf of the Barton Center to the Georgia Child Welfare Legal Academy this year. And we are so fortunate to have our visiting scholar in practice, Rugh Johnson, with us today. But before we get started, I just want to first introduce myself, because as most of you all know, I'm not Melissa Carter. She, unfortunately, the director of the Barton Center, she couldn't be here today. She had a conflicting meeting, so I'm here in her stead. My name is Terrence Wilson. I am the Robin Nash Postgraduate Legal Fellow at the Barton Center. So I'm an attorney that's here working on quite a few projects supporting the work of the center. And so one of the things that we've been working on is the Child Abuse Registry. We've had students researching, and we know that it's a really hot topic, and we feel like we've got one of the eminent visiting scholars right here in Georgia that can talk to us about it today. But before we get to the presentation, I just want to make a couple of announcements. We're going to do like we're at the movie theater, so please silence your cell phones, if you will, put them on vibrate. Just want to let you all know that the program today is going to conclude at 4:15, and we're going to take a break somewhere in the middle. So if you could just hold out until there's a break time, and Ms. Johnson is going to tell you when that break time is going to be. We want to make sure you registered at the table in the hallway out to your left. So if you go out these doors, the registration table is over here. So please make sure you register, pick up your materials that we have for you today, and sign up for CLE credits. As you all know, there are going to be 2 hours worth of CLE credit for today's presentation. Program evaluation is included in your handouts today. The evaluation results will be compiled to help us determine what we want to do for future legal academies. Please complete these and return them to Michelle, who I don't see, but Michelle's at the registration table. And when you give in your completed application, evaluation rather, you will receive your parking validation ticket. So that's our way of encouraging you to do your evaluation. If you want to get your parking validated, do your evaluation. The certificates will be available at the end of the program for those that have pre-registered. Walk-ins, you will receive your certificate, your CLE certificate via email. If you have a question, please try to state it clearly. We're going to restate the questions because we are recording this presentation. And so we have a microphone up here. So please try to state your question as clear as possible so that we can restate it for the benefit of those who are not here. The restrooms are located in this outer hallway, out the doors to your right. We do recycle, so we do have recycling bins. Please don't throw your trash in the recycling bin. Please pay attention to that as well. And information about future legal academies that we'll have are going to be posted on the law school's website, which is law.emory.edu, and the Barton Center website, which is bartoncenter.net. And then we also want to give a really big thank you to the Supreme Court of Georgia Committee on Justice for Children for financing and planning support for the child welfare legal academies here in Georgia. So at this point, I'm going to introduce our visiting scholar in practice, Rugh Johnson. She holds an MS in biochemistry from Clemson University and a JD from Georgia State University. She is a pro tem judge in DeKalb County Juvenile Court and a certified child welfare law specialist. Diana is a member of the Supreme Court Committee on Justice for Children, the steering committee of the ABA Parent Representation Project, and the board of directors of the Georgia Association of Counsel for Children. She teaches on a variety of topics, including trial skills, drug testing, and medically complicated cases. Without further ado, I want you to join me in welcoming Rugh Johnson.
Good afternoon. Before I start, I'd like to know who I've got here. How many child attorneys do we have? And agency attorneys? Parent attorneys? Other? And what does the other represent? So, okay, you got out of the trenches and you're not going back? Okay, so Georgia's new child abuse registry. I am going to start today talking about the history of Georgia's Child Abuse Registry, and I think that's important because Georgia's original Child Abuse Registry was ruled unconstitutional back in 1998, which was before a lot of the people in this room started practicing law. We'll also talk about the details of the registry itself, the timelines for asking for hearings, the administrative hearings themselves, the judicial review of administrative hearings, ways in which an alleged abuser's name can be removed from the registry, who has access to the registry, as well as any constitutional issues that may arise. And I'm also going to talk about what I call red flags, and those are problems with the way that the law is written and things that can go wrong at the hearing level. So when we have a new law, one of the hardest parts about a new law is getting it through the legislature. And I think that so much time and energy is spent doing that there isn't a lot of time in that process to iron out the details and to work on kind of the finer points. And we all know this because we have our great new juvenile code that passed in 2014, and we're all like, yay, and then within like the first 2 weeks in the courtroom, we were like, ooh, that doesn't really work the way we thought it was going to work. And so those are just the normal growing pains of having a new law. So no matter how great it is, there are always going to be problems. So I think one of the most exciting things about doing this talk is that most of you here are those attorneys in the trenches who are dealing, if not directly with those hearings, questioning whether or not someone needs to be on the registry. You are dealing directly with the parents and the children who are affected by themselves or someone in the family being on the registry. So the other part of being one of the lawyers in the trenches is that I know that when I was in the trenches full-time, I really wasn't doing anything but hearings constantly. So I didn't have a lot of time to spend thinking about constitutional issues and legislation. But luckily, we have among us, and actually here today, some of the attorneys who I consider a little more higher-minded, a little more connected to what's going on in the legislature. So when you come across things in this law that don't work or you feel are harmful to children or families, you have people you can talk to who maybe have an easier time getting the ear of the legislature. And so among them are obviously Melissa Carter here at the Barton Center, Jane Okersinski, who's here, the executive director of the Georgia Association of Counsel for Children, Carolyn Altman, who I don't think is here, but she's the new president of the Parent Attorney Advocacy Committee. We've got Jim Outman here, who does a lot of legislative work with the Georgia Council of Adoption Lawyers, and of course, Mary Margaret Oliver, who was actually a sponsor on this bill and is very involved in children's issues. So we can always call on these folks when we identify those parts of this law that are absolutely not working for children and not working for families. So we've got a lot of material to cover, and I want to save enough time at the end to have some discussion and questions. So what's the purpose of a child abuse registry? Well, as a state, we want children to be safe. We want them to be safe at daycare, at school, with their CASA workers, when they're in foster care, when they're in their adoptive homes. So we also want child abuse investigators to have ready access to information about past child abuse cases, about past offenders. And as a state, we want to keep accurate data on child safety. So we want to have good statistics to support the things, for instance, that we're asking for from our legislature, including money. So I'll note that when making these slides, sometimes it's a little awkward to fit whether it's the case citation or the statute citation into the body of the slide itself. So anytime I haven't done that, I try to list case citations and statute citations there at the very bottom of the slide. And I think I've managed to do that on all of my slides. So let's talk about the old child abuse registry. It had the same name as the new one. It's CPSIS, the Child Protective Services Information System. The old registry was a little confusing. DFACs, when they would investigate a case and they would come to the end of their investigation, they would put the case into one of three categories: unfounded, confirmed, or unconfirmed. And those descriptions are very confusing, and I'm glad that we've done away with them. So now we're working with substantiated or unsubstantiated, which is a lot more clear. So under the old registry, DFACS still had to inform the alleged abuser that the investigation had concluded and whether or not his or her name was now included on the registry, and also of the right to a hearing before an administrative law judge. And the administrative law judge, when that hearing came before him, would determine whether the evidence met whatever the confusing standard was for classification. But there was a caveat in there. In that administrative law hearing, no party could compel testimony from a child under the age of 14. Well, when we're talking about child abuse, that seems like a bit of a due process violation. And the administrative law judge's decision could be appealed to the Superior Court, which is the natural way that administrative decisions are appealed, but written into that law was the fact that it couldn't be appealed any further than the Superior Court. So that registry existed until State v. Jackson. So in State v. Jackson, a guy by the name of Bart Jackson was accused of child molestation. There was a DFACS investigation. There was also an investigation by law enforcement. Mr. Jackson received notice that DFACS had concluded their investigation, had classified him as a confirmed child abuser, and was entering his name on the registry. He went through the procedure to request a hearing before an administrative law judge. In the meantime, he was also arrested and charged with 5 counts of child molestation. And the administrative law judge in that case postponed the administrative hearing until after the criminal hearing had concluded. Well, Mr. Jackson was tried, and he was acquitted on all 5 counts of child molestation. But DFACS still wanted to keep him on the child abuse registry. So Mr. Jackson filed a case in Superior Court challenging the constitutionality of Georgia's child abuse registry, specifically OCGA 49.5.183.1. And he made several arguments. But one of the arguments that he made was about not being able to call a child witness. He argued that that violated his Sixth Amendment right to due process. Well, the state's argument was, you don't have a Sixth Amendment right. You don't get to confront witnesses because we're not trying to lock you up. So there's no liberty interest involved. So the Sixth Amendment doesn't really matter, doesn't apply here. So the Superior Court reviewed the case, and they agreed with Jackson. And the state appealed, even though the law said that no one could appeal beyond the Superior Court. But it happened anyway. And the case went to the Georgia Supreme Court. And the Georgia Supreme Court ruled that Mr. Jackson, in fact, was entitled to due process protections, that 49.5.183.1 was unconstitutional, and eventually the legislature went back and repealed all 8 statutes that constituted the child abuse registry. So we were actually without an official child abuse registry until now. So our new registry does not prohibit compelling testimony from a child under the age of 14, but it may or may not violate due process in other ways. And I'm sure that we'll soon see some challenges, and we may see some challenges from some of the attorneys in this room. So placement on the new registry is regulated by the outcome of the CPS investigation. Was it substantiated or unsubstantiated? If the abuse or neglect was substantiated, the alleged abuser's name is automatically placed on the child abuse registry, and the alleged abuser receives notice of the right to appeal and the right to be represented by counsel. So these are the timelines associated with our new child abuse registry. The alleged abuser has 10 days to request a hearing. That request for hearing goes straight to DFACS. Upon receiving a request for hearing, DFACS then informs the Office of State Administrative Hearings, OSA, that a hearing has been requested. OSA has to schedule that hearing within 30 days and has to give the parties at least 10 days notice. Now, hearings can be postponed. They can be postponed by mutual consent, can also be postponed if counsel needs to be appointed for a minor. So we have a lot of child attorneys in the room, which I'm glad about, because minors on the registry, I think, is a huge issue for Georgia's new child abuse registry. So minors can be listed on the child abuse registry, which I think creates its own questions and potential problems. And the minor is entitled to the same notice that an adult alleged abuser is entitled to. But the statutes themselves aren't very clear about, is it the minor who has to, is the letter addressed to the minor? Does that green card for certified mail, does it have to be signed by the minor, or is it signed by an adult in the household? And if an adult has to sign for it, I don't know that that necessarily provides any extra protection, because that adult may not be any more equipped than the minor to understand the right to appeal, the right to counsel, or the potential consequences of being on the registry, or to really understand if maybe placement on the registry was erroneous or unjustified. The other problem with having an adult sign is that the parent or guardian or adult in this house may have adverse interest to the minor. They may be the accuser. They may have been the mandated reporter. So I don't know that that necessarily protects that minor's due process rights. And what if the minor's in foster care? Well, DFACS made the substantiated finding. DFACS provides the notice. DFACS is also the legal custodian, and DFACS is also the opposing party in the hearing. So that kind of leaves in question who is left to look out for the rights of the minor. So the good news is that it does state that minors are entitled to counsel. But it's not a matter of the minor being under 18 at the time the alleged offense was committed or at the time that the case was substantiated. You have to be under 18 at the time the hearing finally comes around. Now the statute, this is where it gets really confusing for me, says that the minor can be represented by a parent or a legal guardian or an attorney retained by the parent or legal guardian. So my question is, can a parent or a legal guardian who is not an attorney represent a minor at an administrative law hearing, and would that constitute the unlicensed practice of law? And as I pointed out before, sometimes that parent or legal guardian is adverse to the minor. And sometimes the minor's in DFACS custody, and then DFACS is also the opposing party. So there is a provision for the administrative law judge to order DFACS to apply to the superior court in that county to have counsel appointed for the minor. And the statute says that the expense is borne by the county. And it's not clear if it's the county DFACS, we're not really sure. But in any case, if an attorney has to be appointed for a minor, then that is good cause for continuing the hearing. So that wasn't great news, but if you're an adult, the news is worse, because there is no right to indigent defense for an adult. So the right to be represented by counsel is referenced in 49.5.183.2, and that's in the notice that the adult receives of placement on the registry. But unlike a dependency hearing or a criminal hearing, there is no right to court-appointed counsel for an adult who's indigent. And so this brings up some interesting kind of ethics and professionalism issues. I already talked about the issue of whether or not a parent or legal guardian who's not an attorney can represent a minor. But for adults, once I got through reading the statute and processing my outrage about the lack of appointed counsel for an accused adult, I found that I had overlooked a really interesting problem that one of my friends who's a SAG brought up, and that is that all the pre-hearing issues in the Office of State Administrative Hearings are dealt with by email. So you are emailing your witness lists, you are emailing lists of exhibits that you are going to present, and so that puts a SAG in the position of communicating directly with a parent who, in that OSA world, is unrepresented. So that's ethically okay, but it feels really weird to the SAG because that SAG would never, in the dependency side of it, have direct communication with that parent. They would always go through the parent attorney. And I've heard from SAGs that it's kind of an oogie feeling. Some of them actually go so far as to then follow back up with the dependency parent attorney just to say, I had the following communication with your client in this other hearing. But ethically, I suppose it's okay. So the OSA hearing itself, it's a real evidentiary hearing. So there's no hearsay, the rules of evidence apply, which also gets a little funny because in a lot of cases, the hearing that actually happens is the PPH hearing. And so those CPS investigators are very used to testifying, but they're also very used to relying on hearsay about what the cop told them or what the doctor told them. So they kind of have to recalibrate in that sense. And the administrative law judge is your finder of fact, and the evidentiary standard for this hearing is by the preponderance of the evidence. So the administrative law judge has to determine whether child abuse was committed by the abuser to justify the investigator substantiating the case. Also in these hearings, res judicata and collateral estoppel apply. So if there has already been an adjudication in juvenile court, in some cases that makes the administrative hearing a little bit easier, and in some cases it doesn't. And we'll talk a little bit more about those kinds of cases in detail. Because they're not necessarily a slam dunk. So within 5 business days of the hearing, the ALJ will issue a written decision. And I've heard that these written decisions are very well thought out, very well reasoned. Whether you win or you lose, you know exactly why. And if the evidence fell short of that preponderance standard, the administrative law judge will order that that alleged abuser's name be removed from the child abuse registry. Either party in the case can request judicial review, and that judicial review is done by the Superior Court. So a petition for judicial review has to be filed within 10 days of the entry of the ALJ's decision. And you petition to the Superior Court of the county where the hearing took place, which may not necessarily be the county where the abuse occurred or the county where the dependency case is being tried, because we do not have one ALJ per county. It's more of a circuit, although it doesn't necessarily correspond to the circuits that we think of in dependency. And if the hearing occurred by phone, which actually is an option, then the petition goes to the Fulton County Superior Court. So the Superior Court conducts a review, and according to the registry statutes, has to render a decision within 30 days of the filing of the petition. But I'm a little clear on whether that timeline is enforceable. And so what's unclear to me is that OCGA 501319E gives the Superior Court 19 days. Gives the Superior Court 30 days from the service of the petition for the record to be transferred to the Superior Court. And then it gives the Superior Court the option of asking for briefing or even awarding oral argument. So if the registry statute imposes that 30-day deadline for decision, I'm not sure how that's reconciled. And I cannot imagine a Superior Court that wants, especially a constitutional issue, to be briefed and wants to hear oral arguments. I can't imagine a Superior Court judge feeling that they were constrained against doing that. But to my knowledge, that issue has not yet come up. So the judicial review by the Superior Court is regulated by 501319. The Superior Court, much like our Court of Appeals, when they hear our dependency appeals, they cannot reweigh the evidence. Their options are to affirm, remand, reverse, or actually modify the decision of the ALJ. And I've listed the bases for reversal or modification up here on the slide. And there is not a restriction on further appeal. And I guess depending on whether it's an issue of law or a constitutional issue, it's left up to you to figure out whether you're going to the Court of Appeals or the Superior or the Georgia Supreme Court. So I've talked about how you get on the registry, and I've talked about that initial appeal for how to get a name off of the registry. But let's talk about a couple of other options. So for minors, a minor's name that is on the registry should be automatically removed at the time that child turns 18, or can be removed after 1 year if there are no subsequent substantiated cases against that child, or upon a showing of rehabilitation by a preponderance of the evidence. The 1 year with no substantiated cases, I'm not sure if that happens automatically, and I would kind of put the burden on the child attorneys that you may want to go back and check to make sure that that happens for your client. And also the showing of rehabilitation. So we've got a lot of kids, especially our dually involved kids, who may have been charged with child molestation or something similar and have gone off to treatment at Twin Cedars or Chris Kids and completed treatment. So that to me would be the evidence that you would show that rehabilitation has occurred, but the statute doesn't tell us to whom you make that case for rehabilitation, whether you go back to DFACS to say that the child has been rehabilitated, or if you have to request a hearing before the administrative law judge to show that rehabilitation has occurred. And I'll talk later about the process of self-inquiry, where a minor or an adult can inquire to find out if their name is listed on the registry. So for adults, we've got a statute in here that's all about expungement hearings. So when I saw that, I was like, great news. There's a way to get off of the child abuse registry. And it says that adults are entitled to an expungement hearing. Adults are entitled to an expungement hearing if they have not previously waived the right to a hearing, meaning they got the letter in the mail, they signed the green card, it went back to DFACS, and they never requested a hearing. That would be considered waiver of the hearing. But if you never got notice and you didn't request and you never had the opportunity to request a hearing, you would think, well, now I found out I'm on the registry, I never got the chance to file that initial hearing, now I'm going to file for expungement because the reason I was placed on the registry was bogus. Unfortunately, the only basis for removal from the registry at an expungement hearing is mistaken identity. So if I find out that I'm on that registry and I had never been given notice that I was on that registry, the only way that I can get my name back off of there is to prove that I am not the Diana Johnson, age 45, who lives in Decatur, Georgia, who had a substantiated case. And the statute itself says, upon a finding that there is no credible evidence that the individual who requested the hearing is the individual who had a substantiated case, the State Office of Administrative Hearings shall order the division to expunge the name from the registry. That's it. That's the only way an adult is going to get off of the child abuse registry. So if it really is me, but I didn't get notice, there's no way for me to go back and challenge whether that was a valid substantiation of child abuse or neglect against me. So this is the big place where I think the constitutional challenges can happen, and I hope a lot of you will be keeping your eyes out for cases like that. So let's take a little bit of a break. I want you to process that before we go, before we start talking about the other red flags. Okay, are we ready? So let's talk about access to information that is on the new child abuse registry. So the hearings associated with the files associated with these ALJ hearings are confidential. They cannot be viewed by the public, and the hearings themselves are closed to the public. And the unauthorized release, unauthorized access, or attempted unauthorized access to files and hearings and registry information is considered a misdemeanor. So who does have access to registry information? Mostly the access is for licensing purposes. So we're talking about licensing of entities, licensing of individuals. Even though it's not specifically listed in the access statutes, ICPC access is being allowed, pretty much as it has always been with the SHINE system. Also, the Department of Early Care and Learning has access to registry information, so they can, I guess, run their job applications and their employee names through the registry. CASA has access to registry information, but only for screening of their employees and their volunteers. They do not have access for investigating their own cases. So there is also expected to be yearly statistical reports that go to the governor's office, to prosecutors, and to law enforcement about child abuse registry numbers. No names actually go out to those entities. And as I was going through this, it occurred to me that a lot of the danger that children face from adults and a lot of places that registry information could be useful aren't actually included in access to the registry. So you think about the Boy Scouts, the Girl Scouts, the church nursery, youth group leaders. There's currently no access for those sorts of groups. And I would also love to see some statistical reports on who is actually accessing the registry. Because at this point, under Georgia law, even though the entities that I listed before are able to access the registry, I don't think that it's mandatory in any of their hiring processes that they do. It's mandatory for a lot of them to run GCIC or NCIC criminal background checks, but at this point, it's not mandatory to check the child abuse registry. And I think that would be really informative just in terms of assessing child safety, but I think it's also really informative for those of you who represent parents and represent children who maybe end up on the registry to kind of find out exactly what would be the consequence of ending up on the registry. Is the registry going to keep my child client from getting a TeenWorks job at the Y, to eventually to doing any kind of work with children in a hospital setting, in a daycare setting? So it would be nice to know who's actually utilizing the registry information. So I talked a little bit about the growing pains that we experience when we get a new law, and that slowly things start to resolve, and someone makes a squawk about something, and we figure out that maybe this part of the law isn't working. And so I'm happy to report that I spoke to the adoption attorneys at a CLE back on November 4th, and at that point, there was no access for licensed child placing agencies to registry information. So a prospective adoptive parent whose agency was requiring verification of a child abuse registry search had to make an individual request to DFACS for verification that they were not on the registry, because the child placing agency did not have that access. Now, if an individual inquiry is made, DFACS has the duty to tell that person, yes, you're on the registry, no, you're not on the registry. If the answer is yes, you are on the registry, DFACS has to tell you the date on which your name was added to the registry. They don't have to tell you the reason. They don't have to tell you the alleged victim. So if, and again, if you never got notice of the fact that you are on the registry, unless it was a mistaken identity, you also have no opportunity to challenge the listing. So back when I gave the talk to the adoption attorneys, this is what prospective adoptive parents were having to do. So this is the procedure for self-inquiry, which would probably be very useful, especially for the child attorneys, if you're worried that any of your kids are on the registry or their names have not been appropriately removed from the registry. So the name of the website, the website address is down here. The Child Abuse Registry has its own website, and you go under the tab for screening request. And there at the top, there is a section for self-check, and circled there is self-screening form. That should take you to a PDF copy of the self-request form, and the person making the inquiry has to fill that out themselves. And even though there is a space, there is a place on the website to submit a screening request. That option is not available to individuals making a request, so you'll get that pop-up message there. The individual making the request has to bring the completed form along with an approved form of government ID, whether it's a driver's license, passport, military ID, to a DFACS office. And that is apparently where the screening is done. If you're in that situation, I would call ahead once you decide which DFACS office you're going to, because I'm pretty sure they're not getting a lot of these, and you do not want to waste a trip out there and end up talking to someone who has no idea what it is you're asking for. But as of November 21st, 2016, it has been decided that child placing agencies can have access to registry information. And this was not a change to the law, it was actually a change, kind of a change to DFACS policy and how they chose to interpret the law. And so basically the law, I read the memo that went out to the child placing agencies, and so their logic was that because child placing agencies have to assess the care and shelter for children, and they have to comply with state laws that regulate that affect children and regulate agency operation, that they needed to have access to child abuse registry information. So now child placing agencies can submit a screening request via the online portal. But I'm glad that that had not changed before I did the last CLE, because otherwise Jim Outman and I would not have gone through and figured out exactly how to complete a self-inquiry, because it really wasn't that clear when we started to ask those questions. So even though we have a child abuse registry now, historical information about substantiated cases prior to July 1st, 2016 is still being maintained. So the child abuse registry is not the only source of information about prior substantiated cases. The SHINE system is still in place, and it can still be used to check CPS history for all kinds of reasons. And access to SHINE's information is regulated by OCGA 49.541. So even though we haven't had an official child abuse registry all this time, we kind of have. So let's talk about constitutional issues. I am absolutely not a constitutional scholar. So credit for most of these next few slides go to John Farmer, who is a law student at the University of Georgia, and he was an intern of Emma Hetherington at the CEAS Clinic. And he did a lot of research on constitutional issues before Emma put on her training for the administrative law judges back in June. So we all know what a due process violation kind of smells like or feels like. And so when we actually make that constitutional inquiry about a due process violation, it's a two-part analysis. And the first part of that analysis is whether or not there's a deprivation of a liberty or a property interest. So the question is, and this has been fought in various federal circuits, is it just reputational harm? Because that's a hard argument to make, because that child abuse registry isn't printed up in the daily report. There's very limited access to it, so really, how much reputational harm is there? Is there a bar from the prospect of employment, Or can the aggrieved person show a bar from actual employment? And I think that where a really compelling case would come from is not someone who thinks maybe they'd like to work at a daycare someday, but maybe somebody who is a licensed teacher, licensed pediatric nurse, working in some capacity where these checks are now going to be made as an ongoing part of the employment process. So suddenly having a name appearing on the child abuse registry does constitute a real threat to current employment. So the second question is whether or not there are sufficient procedural protections in place for the alleged abuser. So you look at whatever that interest was that was identified in step 1, and we ask, what's the risk of the alleged abuser being erroneously deprived of that interest? And you also look at what the state's interest is, and how burdensome would it be to the state to put additional procedural protections in place. So as we look at that due process problem, there are some other considerations, especially for Georgia's child abuse registry. In other states, the placement on the registry is not automatic, and that appeal process actually happens before the placement of the name on the registry. But here in Georgia, we've got a situation where that notice and the opportunity to be heard happens after the name is already on the registry. And that if you count out the timeline, the time from placement of a name on the registry until the completion of the ALJ hearing could be more than 50 days. So even if you win removal, you were a registered child abuser for 50 or so days. Longer if you then go and appeal to the Superior Court. So one factor that works against a due process challenge here under Georgia's registry is our use of the preponderance of the evidence standard. So states where due process challenges have been successful in federal court and have been upheld, it's those states that use the any evidence standard. So the preponderance of the evidence standard is actually considered a protective factor for the alleged abuser. On the other hand, we have the argument that that preponderance standard is employed by an investigator with no judicial oversight. And I think that as attorneys, we constantly struggle with, well, exactly, does that mean a preponderance? And we're constantly asking ourselves that question. So I really can't imagine a social worker a couple years out of school having to make that determination without any judicial oversight. The other factor that works against a due process challenge here in Georgia is that employees, as I said before, employers are not required by law to check this child abuse registry in their hiring process. I think that now that the registry is in place, most employers will, just as a way of covering themselves from any potential liability. But at this point, it's not law that they've got to check it when making hiring decisions. So the right to counsel is also something that I saw a lot of people kind of buck up about when we talked about that right to counsel. So I talked before about this idea of a minor being represented by a parent or a guardian. But there's a safeguard in there because the minor does have the opportunity to have court-appointed counsel. So I cannot envision a situation where a minor would be forced to go forward into one of these administrative hearings without any representation. But of course, we have no guarantee of counsel for indigent adults. So the question for a constitutional challenge of right to counsel is whether that ALJ hearing is sufficiently analogous to a dependency hearing in juvenile court or to a criminal hearing where we know that the right to counsel is a constitutional issue. And so there's an interesting argument that could be made, and this was pointed out by Mr. Ford at UGA, who did this research. And that's the case of Douglas v. California, which is a U.S. Supreme Court case dealing with the right to counsel on the direct appeal of a criminal conviction. And the Supreme Court said that where the merits of the one and only appeal that an indigent has of right are decided without the benefit of counsel, we think that an unconstitutional line has been drawn between the rich and the poor. So is the OSA hearing sufficiently analogous to the direct appeal of a criminal case, because the alleged abuser only gets one shot at having the name removed. So I, of course, think it's sufficiently analogous, but I'm sure there are just as many attorneys who would say that it's not. So let's talk about red flags. One of the first red flags that came up after July 1st, when these hearings started to take place, was this wording of the substantiated case. The statute doesn't talk about the incident of alleged abuse. They talk about a substantiated case. So when does a substantiated case occur? Does it occur when the alleged abuse happened, or does it occur on the day that the CPS investigator checks that box and says that it's substantiated? And I know that the SAGs and the ALJs kind of went around and around about it. I don't know that it was ever decided, but luckily, as we get further and further away from July 1st, that issue is coming up less and less. So the other kind of weird thing is OCGA 49.5-183A1, which is what says, case substantiated, name goes onto the registry. Well, if you read a little bit further into subsection F, when it talks about appealing the case to the Superior Court, there's a little provision in there that says, appealing the case to the Superior Court stays the placement of the alleged abuser's name being placed on the registry, which I don't understand because the name is already on the registry. So that's got to be resolved, because that's just a blatant conflict between two of the code sections. So the other red flag for me is the idea of eligible perpetrators. And that term's used a lot in Illinois, where there has been a ton of litigation regarding the child abuse registry there. So we start by looking at 1975B4. And the reason that that statute is important is that 49.5-180 Section 5 tells us that for registry purposes, child abuse has the same meaning as in 1975B4. And you can all read the definition that's up there on the slide. And the most important part is that in Title 19, when you're talking about physical injury or death to a child, under that statute, it must be inflicted by a parent or caregiver in order to be child abuse. Same with neglect or exploitation. Now, for sexual abuse or sexual exploitation, the perpetrator could be anyone, and it's still considered child abuse. So it doesn't have to be done by a parent or a caretaker. So for physical injury or death, or neglect or exploitation, what if the perpetrator's not the parent? What if the perpetrator is not even a caretaker? That's not child abuse for the purpose of the child abuse registry. So when we think about the cases that we have and who those non-parents or non-caretakers could be, it could be the significant other of a parent, it could be another adult in the household, it could be a visitor to the household, a visitor to the school, to the daycare, a sibling, cousin, visiting child, or a foster child. So when a minor is placed on the registry, I think the first question to ask is, was that minor the parent of the injured child or a caretaker of the injured child? Because if not, that minor is not supposed to be on the registry. And I suspect that there have been a lot of kind of sloppy coding and substantiating of these cases where minors are erroneously ending up on the registry for something that feels like child abuse, but according to the statute, does not meet the definition. So there's also a problem with the fact that the statutory definition of child abuse under 1975B4 in a lot of cases does not exactly match up with the Georgia maltreatment codes, which is what DFACS uses to kind of categorize the abuse or neglect that's happened. And I did include copies of the Georgia maltreatment code with your slides. So we already talked about emotional abuse. So emotional abuse defects was tending to substantiate for emotional abuse for good reason, because it's in our juvenile code. We have a statute that describes emotional abuse. Unfortunately, emotional abuse is not included in Title 19. So emotional abuse can get your kid taken away from you, but it's not going to land you on the child abuse registry. And I have heard that the ALJs have thrown out some cases because they were substantiated on emotional abuse. So there's a similar problem for subjecting a child to domestic violence where the child isn't physically injured. Again, that can land a child in foster care, but it's not necessarily going to land the parent in the abuse registry. So if you look in the Georgia maltreatment codes at E3 for family violence, domestic violence, intimate partner violence, the perpetrator under the maltreatment code can be a former spouse, foster child, person formerly living in the household. And the violence has to be committed in the presence of the child where the child can see or hear. And under the maltreatment code, there's no injury to the child required. But again, that doesn't meet the statutory definition of abuse under Title 19. So it's not going to support a listing on the registry. Also, when going through the new statute, I was extremely concerned about this idea of false positives. So we think about the number of cases that get dismissed at the PPH hearing or get dismissed at adjudication or even at the criminal trial. So these alleged perpetrators, even though they're acquitted, the petition against them is dismissed, there's, the juvenile court case is closed, that's not a guarantee that they're going to get removed from the child abuse registry. So, and I've heard the argument, well, they were acquitted at the criminal trial, but that's a reasonable doubt standard. Or even having a case dismissed at the dependency adjudication, that's a clear and convincing evidence standard. But for dismissal at the PPH, that's a preponderance of the evidence. And that, to me, should match up with removal from the registry. And I think in a lot of cases it does, just because the timeline for PPH is so quick, especially here in the metro counties. But if that PPH is delayed until after that window of appeal, the person's still stuck on the registry. And I especially think about the really complicated cases where we have to bump out adjudication for a month to 3 months, these complicated medical trials. So you could win one of those and you're still going to be on the child abuse registry. And the criminal acquittal, that could take 4 years. So there's the question of the analogy between the police and CPS investigators. And I've heard this from a lot of people who've just kind of come up with it independently as they're thinking about these cases. When we think about the sex offender registry, to be placed on the sex offender registry, you don't just have to be arrested at a probable cause standard for some kind of sex offense, you've actually got to be convicted. But the child abuse registry, it's simply being substantiated at that probable cause standard. And that's not decided by a judge who's deciding whether or not to issue a warrant. It's only decided by a CPS investigator without that judicial oversight. So interestingly, in Illinois, there was a case called Dupuy v. Samuels, which has actually come back into the federal court twice. So there's Dupuy 1 and Dupuy 2. But in the first iteration of the Dupuy case, the plaintiffs asked for a preliminary injunction. And the question was whether or not we could rely on the employment of this probable cause standard to substantiate a case, because at that time in Illinois, there was no requirement that the CPS investigator do a full investigation in the sense of going out to seek out exculpatory evidence. And there was a preliminary injunction, and in that case, the judge forced DFACS, or DCFS as it's called in Illinois, to make a new policy that said that the Child Protection Agency has to consider all evidence, both inculpatory and exculpatory, in an investigation into a suspected incident of child abuse. So I went into Georgia DFACS policy, and that's actually already a part of Georgia DFACS policy. In 5.1, it says that the investigator has to review and analyze reports, assessments, and physical evidence gathered that supports or refutes the allegations of child abuse and neglect. So that's good, that's already in there. But again, I start to think about those more complicated cases, those medical cases. And now we're going to put a CPS investigator in a position of having to weigh conflicting medical reports and conflicting medical evidence in that very short timeline that they have to assess that information in what we know is going to take a judge a day or two at trial to fully assess and analyze. So I'm not sure that I'm glad that it's in there, but I'm not sure that that's that great a protection. So the other thing that struck me as a potential problem in some of these hearings would be the misapplication of collateral estoppel or res judicata. So collateral estoppel and res judicata require that there be an identity of the parties, of the cause of action, that the issue itself was previously adjudicated by a court of competent jurisdiction, and that there was a full and fair opportunity to litigate the issue in the first action. So some of these ALJ hearings are kind of shortcutted in that we've already got here, here's my certified copy of the adjudicatory order, which in certain circumstances could be just about everything that administrative law judge needs to know to say, yes, this case is substantiated, you're staying on the registry. But we have a lot of situations in juvenile court where the person who is the accused abuser is not a party to the case. So we don't have the identity of party, and that person has not had a full and fair opportunity to litigate in the first case. So if the accused abuser is a non-parent, or if even a putative father isn't necessarily considered a party to the case. So in that case, that certified copy of the adjudicatory order from the juvenile court is not going to be that useful to the ALJ. And also remember that dependency in Georgia focuses on the needs of the child, and that's regardless of parental fault. So a court can find that a child is dependent because the child has, for instance, physical injuries that cannot be explained by either parent. So that child can be found dependent and can be placed in foster care for that reason without the court ever having to make a finding of fact of who the perpetrator was. So in a case like that adjudicatory order isn't really going to give the administrative law judge any additional information. And they'll have to go ahead and have a full hearing. You also, I think that there's a potential problem if we start to look very closely at the way the abuse is coded. So again, going back to those maltreatment codes, I know that I've seen a lot of cases where the neglect is substantiated for abandonment because mom's running the street, she left a child at her friend's house, disappeared for 3 weeks. We substantiate for abandonment, we adjudicate for abandonment, but if you go back and you look at the maltreatment code, in order to substantiate for abandonment at the CPS level, that abandonment has to have occurred for 6 months. So that 3 weeks, no matter how outrageous it is not going to get someone placed on the child abuse registry. So those are all of the red flags that I've identified. And I know we have some people in the room who have actually litigated these hearings. So I'd love to hear either some insight from them, and I'll take questions, and I think there might actually be people in the room who might be more qualified to answer the questions that some of you may have. So I'll just open up the floor.
And
yes.
One of the things I was noticing on the red flags, when you listed what child abuse means, you forgot a fifth element in that. It means also endangering a child. reason why that's important is under the domestic violence situations we've been talking about, instead of labeling as E3 for the emotional use, they're labeling everything now as endangering a child, which is defined within the statute, within 19, and there's very specific requirements. It's felonious assault, and there's two other provisions within that. But at that point, you're having to ask the investigators to really make a legal determination of whether or not, let's take the felonious assault, of whether or not a parent has committed a felonious assault to then justify the endangering a child.
So that makes the hearing
Substantiation.
even more interesting.
Absolutely. So all of the, you're absolutely right. All of those domestic violence, family violence incidents, it's been determined by the state, don't ever substantiate anything under E3. And in Shines, they're actually getting rid of that E3 substantiation. But now everything is being, for domestic violence and family violence, everything is going to be substantiated under, if it's appropriate, under the endangering a child. But that burden is extremely difficult because let's say they're not charged with felonious assault. But the case manager says, well, when I think about felonious assault, and they probably may not know what that is, they could then substantiate under the endangering a child.
And do you have any knowledge of how how liberal the ALJs are treating that allegation?
I'm the SAG for Rockdale County, and I have one where I've had a substantiated case on the endangering a child. I apologize. That one, it was originally labeled under as an E3, so it was reversed.
Okay.
I didn't even make an argument because it's impossible
Right.
to win a substantiation under E3 because statutorily it's just not there.
Right.
So in that case, I went in and said, we've got nothing. So I haven't had any arguments on the E3 specifically, slash, I haven't had any arguments on the endangering of a child.
Yeah.
But I know that's going to be a significant element that is going to have to be discussed a lot
Yeah.
because there's no way that a case manager is able to take those legal definitions that are included within endangering a child within Title 19 and make a determination on that.
Right, and I think it'll be interesting. The statistics I'd really like to see are if we can get a yearly report from the ALJs of the kinds of cases that they're substantiating and the kind that they're actually being removed from the registry. And I think it'll also be interesting to track how DFACS changes its policy and the content of its drop-down menus to deal with, whether or not this person needs to be placed on the child abuse registry.
I know they're updating and trying to enhance Shines on several different ways in order to try and align with some of the maltreatment codes and what's gone into the child abuse registry.
Right.
But
And I hope,
think with Shines, it takes a long time to make.
yeah, but I hope that they're working on both ends, and that would be to try to include the offenses that we would all agree probably need to be on the child abuse registry, while being able to exclude things like we didn't pay the light bill and had no electricity for 3 weeks and the kids were late to school, but no one had to go to foster care. So I don't think we necessarily need that parent on the child abuse registry. So I hope that DFACS is doing that work on both ends to get a more accurate representation of whether or not a child is safe.
And I know that there's been many trainings and Vivian and some of her staff are personally going around to the different regions and doing the child abuse registry training for CPS staff. So I do know that they are working on that aspect of it too, is making sure CPS investigators are appropriately making substantiation.
Right.
I think one of the other issues, because I represent Henry County, we've also had is with the emotional abuse, whether it be an E3, et cetera, they actually had their training after they did it. So I had 4 cases of these yesterday, and 2 of them were emotional abuse. And just as he stated, the judge immediately comes in and says, absolutely not, Mr. Overman, we're getting it out. But the one issue, I tried to circumvent it because I knew it was coming on emotional. So I called up to Peachtree and talked to Vivian up there. And the issue we're having with DFACS also is after staffing it with them, when they other sides already submitted their witness list, et cetera, we're like, DFACS has come to me on a couple occasions and been like, we don't want to move forward. We want to just dismiss this case. But we have to go all the way up the line, up to Vivian, and ask her if we can. And I had 2 yesterday where they told me I had to move forward on the case that even DFACS didn't believe in, which is becoming a problem. We have I think I have 2 more of those. So basically, DFACS wants to get out. They realize, even one of the emotional ones, she wanted me to go forward on an emotional abuse one because there was an element of domestic violence, which Pike County, who my firm also represents, told me that these maltreatment codes, they're trying to work them out and modify them so that possibly when there is an element of domestic violence included, they're doing the training to make sure that it is adequately stated as far as which maltreatment code it should go under. A lot of them are trying to get it under inadequate supervision as well. It's kind of a stretch. And I just want to ask a question as far as, has anybody besides me had to up security for these hearings? Because I've had to bring in like 6 bailiffs.
Why, is it because you're getting the whole family coming, or what's?
The whole family is known through DFACS to be very obstinate, I guess is the best way to put it. I've had 3 or 4 of them where I've had to have 4 or 5 bailiffs just to keep them calm through the entire hearing.
And I can see where that would be an issue because the ALJs don't necessarily have their own court space. So they're kind of borrowing court space from a lot of different places. And so I didn't even think of that being an issue. Yes?
Actually, I have two questions. One is about the testimony of a child in these hearings. I work with child advocacy centers,
Okay.
and it's very difficult for an 8-year-old child who's been sexually assaulted by their father to then have to testify in a hearing, yet again, I'm assuming still face-to-face with the offender. Is that correct? I mean, you didn't mention anything about any concerns about the child's testimony.
Well, the child hearsay statute does apply to these hearings.
Oh, it does? So
Yes.
that if the forensic interviewer, for instance, came to testify, or the CPS worker said, Susie told me that this happened, then the child then would not have to testify?
The,
As long as the child is present, like in a Superior Court case?
correct. And you have to give notice to the opposing party that you're employing the child hearsay statute.
Okay. My second question is just access to the registry. I know it says licensed Georgia entities that interact care for children, and I've never been able to get kind of a straight answer on this, so I'm hoping you can give me one. But as child advocacy centers, we hire people who do the forensic interview for DFACS law enforcement relative to an allegation of abuse. And up until this point, we have not been able to see if that person that we want to hire is on the registry. And I wonder if we have to go to them actually doing a self-inquiry, or can we access it?
I'm not an expert on who can access it, and I'm not sure that there necessarily is an expert on who can access it. My suggestion to you would be to try to do an online inquiry. If it gets kicked back, it gets kicked back. But unless you're trying and unless you're voicing that need to DFACS, then they don't have any knowledge of, whether or not they need to reassess their policy the way that they did for the licensed child placing agencies, in terms of adoptions. So that would, they didn't know until the adoption attorneys sort of raised that red flag.
Great, thank you. I'll get them to start doing that. Thanks.
I think my question would be what conversation is being had in regards to teen parents who are in foster care themselves. They have a baby. We still are seeing, I know it's not supposed to happen, but we're still seeing cases where the mother may or may not, she may be brought into custody and the baby's brought into custody at the same time.
Right.
Or she's delivering, well, you're kind of unruly, so we're going to take the baby. So what kind of situations are we seeing, or protection maybe for that mom? Because we're also working with moms who elect to stay in foster care up to 21. So then they fall in that adult category.
Yeah.
So what conversation is being had regarding that population?
I think that falls on you and falls on the child attorneys, and that is a classic case for, I know, but you do a lot. But I think that is a classic case for an appeal for a name to be taken off the registry, because we all know that, sometimes, it's that trickle down of the information that, no, we do not need to take kids into care just because their teen parent is in care. And it, we still see it, even though it's been to the Court of Appeals 4 times, we're still seeing it. But that to me is a pretty easy hearing in front of an ALJ of exactly what did you substantiate this for? And, they used to just kind of throw it under neglect or parental inability or something like that. But when you get right down to the facts of the case, a lot of times there really aren't any.
So what about the notification on that? Defects is the guardian, defects is the accuser.
That parent, even though they're a teen parent, is still supposed to receive that notice. And I would encourage anyone who represents a teen parent to go back to CPS and ask for the notice. Because again, if you don't get the notice, the name goes on the registry, you could wait that year to get the name back off. But again, your client at that time is, going to be barred from certain employment opportunities. Yeah. Any other questions? Yes.
Hi, is there any plan for the historical information to ever be transferred over to the new system?
I don't believe so. I don't think there's a way to kind of grandfather it in under the new child abuse registry, because, the registry is very clear that it's only substantiated cases after July 1st. Anyone else? All right, thank you all for coming.
So on behalf of the Barton Center and Emory Law School, I just want to thank you all for coming out today. Just as a reminder, the evaluations that you have, if you didn't get an evaluation, please come see me. I'll get you one. When you turn your evaluation in, we'll get you your parking voucher. And please look out for the future child welfare legal academies that we have coming up. Look out on the law school's website and the Barton Center's website. Thank you.